Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn that subscription. For today's case, we are dealing with a brand new lawsuit from Twitter against Elon Musk. As we know, there has been an attempt by Elon Musk to buy Twitter, and now he says he wants out. He doesn't want to proceed. Well, Twitter would very much like to proceed, not for the least of reasons that the price he offered is substantially more than the price it's currently worth. So Twitter is trying to enforce the deal. They're trying to get him to force the deal through. And we're going to do this in Delaware, where all the businesses are, including the businesses in question. If you ever have to guess where a business is legally incorporated, it's probably Delaware. So we're in Delaware State Court. And we're in the Court of Chancery of the state of Delaware, which means this is a court of equity. And now the distinction between law and equity is somewhat lost in most of the United States and lost entirely in the United Kingdom as far as I'm aware. But they can offer different kinds of results and different kinds of measures. And one of the measures the Court of Equity can do, or the Court of Chancery as it's called in Delaware, one of the things they can do is issue the remedy of specific performance. That is, requiring the parties to go through on the thing, which a court of law cannot order that performance. That's an equitable remedy, not a legal remedy. These distinctions, by the way, go way, way back in terms of English law. In more modern American law, these are more merged, so this distinction is less important. But one of the upsides, or one of the interesting aspects, I suppose, of the fact that it's a court of equity rather than a court of law means no jury. So this is going to be tried by a court acting on its own, who will come up with a decision, and we're going to try to figure out what is going on and all this stuff. So let's do that. So we are in Delaware, and we are trying to get this enacted through Delaware State Court. So let's go ahead and read that. In April 2020, Elon Musk entered into a binding merger agreement with Twitter, promising to use his best efforts to get the deal done. Now, less than 3 months later, Musk refused to honor his obligations to Twitter and stockholders because the deal he signs on to no longer serves his personal interests. Of course, this is written in Twitter's voice, so it's going to be a little inflammatory, but should be fun. Having mounted a public spectacle to put Twitter in play, and having proposed and then signed a seller-friendly merger agreement, Musk apparently believes that, unlike every other party subject to Delaware law, he is free to change his mind, trash the company, disrupt the operations, destroy stockholder value, and walk away. This reputation follows a long list of material contract breaches by Musk that have cast a pall over Twitter and its business. Someone really likes their illustrative writing. Someone's using those creative writing skills to maximum effect. Twitter brings his action to enjoin Musk from further breaches, to compel Musk to fulfill his legal obligations, and compel consummation of the merger upon satisfaction, which would be specific performance. We want him to actually go forward and buy the thing. Okay, Musk is Musk. On April the 25th of 2022, Musk, acting through and with his solely owned parent entities, Parent and Acquisition Sub, agreed to buy Twitter for $54.20 per share in cash, which amounts to about $44 billion. That price, presented by Musk on a take-it-or-leave-it basis in an unsolicited public offer, represented a 38% premium over Twitter's unaffected share price. The other terms Musk offered and agreed to were, as he touted, seller-friendly. There's no financing contingency and no diligence condition. Okay. The deal is backed by an airtight deal and equity commitments. I guess we'll find out. Musk has personally committed $33.5 billion. After the merger agreement was signed, the market fell. As the Wall Street Journal recently reported, the value of Musk's stake in Tesla, the anchor of his personal wealth, has declined more than $100 billion from its November 2021 peak. So Musk wants out. Rather than bear the cost of the market downturn as the merger acquisition requires, Musk wants to shift it to Twitter stockholders. This is in keeping with the tactics Musk has deployed against Twitter and stockholders since earlier this year, when he started amassing undisclosed stake in the company and continued to grow his position without requiring notification. It tracks the disdain he has shown for the company that once one would have expected of Musk as it would be steward to protect. Since signing the merger agreement, Musk has repeatedly disparaged Twitter and the deal, creating business risk for Twitter and downward pressure on the share price. Musk's exit strategy is a model of hypocrisy. One of the chief reasons Musk cited on March 31st, 2022 for wanting to buy Twitter was to rid it of the crypto scam he viewed as a major blight on the user experience. Having been personally a victim of a hostile crypto takeover, I am not particularly amenable to the crypto myself, so yeah. Musk said he needed to take the company private because, according to him, purging spam would otherwise be commercially impractical. In his press release announcing the deal on April 25th of 2022, Musk raised a clarion call to defeat the spam bots. Someone really is flexing those creative English writing classes, man. This is, I do kind of enjoy it, to be honest. But when the market declined and the fixed price deal became less attractive, Musk shifted the narrative, suddenly demanding verification that spam was not a serious problem on the platform and claiming a burning need to conduct diligence he had expressly forsworn. Did he really? Did he in writing forswore diligence? If he did, that'd be amazing. Musk's strategy is also a matter of bad faith, while pretending to exercise the narrow right he has under the merger agreement for information for consummation of the transaction. Musk has been working furiously, albeit fruitlessly, nice alliteration, to try to show the company he promised to buy, and not disparage, he has made material representations about his business to regulators and investors. He has also asserted falsely that consummation of merger depends on the results of his fishing expedition and ability to secure debt financing. On July the 8th of 2022, a little over a month after first using bad faith pursuit of spam-related evidence to assert a baseless claim of breach, Musk gave Twitter notice purporting to terminate the agreement. The notice alleges 3 grounds for termination: purported breach of information sharing and cooperation covenants, supposed material inaccurate representations in the merger agreement that allegedly are likely to reasonably result in accompanying material adverse effect, and purported failure to comply with ordinary course covenant by terminating certain key employees, slowing hiring, and failing to retain key personnel. There might be something there, especially on that last one. I mean, they have fired a lot of people recently for some reason. These claims are pretext and lack merit. Twitter has abided by its covenant, and no company material adverse effect has occurred or is reasonably likely to occur. Musk, by contrast, has been acting against this deal since the market started turning, and has breached the merger agreement repeatedly in the process. He's reported to put the deal on hold pending satisfaction of imaginary conditions, breaching his financing efforts obligations in the process, violating his obligations to treat requests for consent reasonably and provide information about financing status, violated non-disparagement obligation, misused confidential information, and otherwise failed to employ required efforts to consummate the acquisition. And then this, of course, is the kind of big ask, and the reason we're in the Court of Chancery. Twitter is entitled to specific performance. We want him to actually be forced to go through a deal. So when you're talking about a breach of contract, which this is basically just a contract, right? It's a contract for a thing. I buy a piece of fruit for $1, or I buy Twitter for $44 billion. It's the same basic deal, right? And so we're suing for breach of contract. And of course, if you successfully prove breach of contract, there are many potential different remedies. You know, you can wind everyone back, make everyone whole, give them what they would have lost, a whole bunch of things. And one of the remedies, and a disfavored remedy at that, is the specific performance, which incidentally is not available in personal services contracts, in case you're curious, which this is not. But yeah, this is an unusual remedy most of the time. Richard Hogue, who would know way more about this than me, says it is not as uncommon in the Court of Chancery in Delaware, which I'm somewhat inclined to believe. So we'll assume that there is some chance, whereas if you tried this, for example, in your local courthouse on a normal day, yeah, not so much. Not so much getting specific performance on a remedy. All right, so plaintiff Twitter is Delaware Corporation. It's incorporated in Delaware, like pretty much every corporation you've ever heard of. They're all incorporated in Delaware. Headquartered in San Francisco. So Delaware is an appropriate venue for this lawsuit because this is the buying of Twitter, which is located in Delaware. So it's the place the property exists. Defendant Elon Musk is a sophisticated entrepreneur who owns approximately 9.6% of Twitter. He's the CEO of Tesla and leads SpaceX, blah, 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 blah. All right. So we have jurisdiction because the company is here. That's fine. The personal jurisdiction over the parent and acquisition sub is proper because both are incorporated under the laws of Delaware. So Elon Musk created some companies to help him as part of the acquisition process. And unsurprisingly, those companies are also based in Delaware because pretty much all companies are. All the big companies, at least, are based in Delaware. You know, your mom and pops may be different, but pretty much every big company you've heard of, almost all of them are based in Delaware. Okay, cool. Personal jurisdiction over Musk is proper pursuant to law because, among other things, he formed parent and acquisition sub both in Delaware that are wholly owned by Musk for the purpose of acquiring Twitter, which is also Delaware Corporation. Musk agreed to undertake reasonable best efforts to consummate, including by parent and acquisition to deliver certificate of merger. I'm going to assume this is way more than enough for personal jurisdiction in Delaware. That sounds fine. All right, so let's go through the accusations. Well, thank you very much, Ronnie, for your nice compliment about my camera. It is a Sony Alpha 5100, which is mentioned in the comments below, and I really appreciate it. I think the Sony does produce good color. Also, it doesn't hurt that I've got the lights set just so to help additionally, but thank you. And let me turn on the super chat so I can see them as they come in. Great. So far, Elise Taylor became a member. Thank you very much for hitting that beautiful join button. Let's read in some more. Musk is active on Twitter's platform and expressed a keen interest in the use and inherent potential of the platform. Starting in January of 2020, Musk began purchasing Twitter stock. By March the 14th, he had secretly accumulated a substantial portion, about 5% of outstanding shares. SEC regulations required he disclose that position not later than March the 24th of 2022. Musk failed to disclose, instead masking Twitter stock with a market none the wiser. That's an issue for him and the SEC. By April the 1st of 2022, Musk had accumulated about 9.1% of the company's outstanding shares still in secret. Not until April the 4th, 2022, did Musk finally disclose his holdings, which made him Twitter's largest shareholder. Twitter's stock price jumped 27% on the disclosure. Between March the 24th and April the 4th, over 112 million Twitter shares traded in ignorance of Musk's mounting ownership. Meanwhile, on March the 22nd of 2022, Musk spoke with two Twitter directors, Jack Dorsey and Egon Durbin, about the future of social media and the prospect of Musk joining the Twitter board. Soon after, Musk told Twitter CEO and Twitter board chair that he had in mind three options relative to Twitter: join the board, take the company private, or start a competitor. Musk would repeat the statement over the coming days. His contemplation of building a rival platform to Twitter was not a secret. On March 26, 2022, he tweeted that he was giving serious thought to the idea. In early April, after further discussion among Musk and others, the Twitter board evaluated Musk's candidacy as a director. Having considered, among other things, Musk's interest in the platform, his technical expertise, and perspectives he could bring, the board offered him a position. Musk accepted, and the parties signed a letter of agreement, and the agreement was announced on April the 5th. Thank you very much for your $4.99 super chat sticker. Sharif, you are a gentleman and a scholar, or a woman and a scholar. Either way, I do appreciate it. Not a week later, Musk abruptly changed tact. On April 9th, the day his appointment on the board was to become effective, Musk told Twitter he would not join the board. Instead, he decided to join the company, or buy the company. On April 13th, 4 days after reversing course of the board seat, Musk texted Taylor he planned to make an offer to acquire all of Twitter. His unsolicited offer, conveyed by letter later that day, was accompanied by a threat. I'm offering to buy 100% of Twitter for $54.20 per share in cash, a 54% premium over the day I began investing in Twitter, and a 38% premium over the day before my investment was publicly announced. My offer is the best and final offer, and not accepted, I would need to reconsider my position as a shareholder. Dun dun dun. The following day, on April the 14th, Musk announced his offer publicly and noted it was conditioned on customary business due diligence and financing. Logical. At a public event the same day, Musk, whose enormous personal wealth exceeds the capital of most public companies, boasted he could technically afford to purchase his Twitter outright. It certainly does have the money. Also on April 14th, the Twitter board met to discuss Musk's proposal. It established a transaction committee composed of independent directors to evaluate the proposal, oversee negotiation, and explore strategic alternatives. The board was assisted in its review by Goldman Sachs and JP Morgan as financial advisors, and Simpson Thacher as an independent counsel. Faced with Musk's rapid accumulation of Twitter stock and take it or leave it offer, and concerned that he might launch a hostile tender offer without notice, the board adopted a customary shareholders' right protection plan to protect its shareholders from coercive or otherwise unfair takeover tactics. The board took this action to reduce the likelihood of a takeover without payment at an appropriate control premium and to ensure the board had sufficient time to make an informed judgment about Musk or anyone else's offer. They were certainly hoping someone else would come to the rescue. Under the right plan's terms, a single investor or group acquisition of more than 15% of the company's outstanding common stock without board approval gives other stockholders the right to acquire additional stock at a considerable discount. The plan was adopted and announced on April the 15th of 2022. The board concerns proved well governed. Musk began making all too obvious public references to a hostile tender offer. At the same time, Musk worked to strengthen the offer he made and might make by tender. By April the 20th, he had personally committed $21 billion in equity financing and lined up $25.5 billion of committed debt financing, with $12.5 billion of it secured by Tesla stock. Having obtained these commitments, Musk announced in an April 21st, 2022 security filing that his offer was no longer conditioned on finance or subject to due diligence. All right, so let's read this and see what this says, because this will be really interesting. At the time of delivery, the proposal was also subject to the completion of financing and business due diligence, but is no longer subject to financing as a result of the reporting person's receipt of financing commitments and is no longer subject to business due diligence. Why you would waive business due diligence, I can't even begin to understand. Why you would waive the financing because they're secured, I get, but why you would ever waive due diligence? Like, you're basically committing to buy it blind. Musk proclaimed himself prepared to begin negotiations immediately and confirmed whether he was explored to commence a tender offer. What offer are they referring to at this point on April 21st, 2022? Let me read about a second. Let me just make sure. Okay. So this is the offer to buy 100% of Twitter for $54.20. Okay. At least the way this is written. Okay. On Saturday, April 23rd, 2022, Musk asked to speak with Twitter representatives about his offer. At direction of the Transaction Committee, Taylor engaged with Musk, who reiterated that his offer was best and final and threatened once again to take Twitter stockholders directly if the board did not engage immediately. The following day, on Sunday, April 24th, 2022, Musk tried again to force Twitter's hand. He delivered a letter to the board repeating that his $54.20 per share offer was best and final, threatening once more to sell all of his shares if his bid was rejected, and saying he would propose a seller-friendly merge agreement to be signed before the market the opening day. Musk's counsel sent over a draft agreement, reiterating that Musk's offer was not contingent on any due diligence, and underscored the form of the proposed agreement was intended to make this easy to go along every step. Okay. Why you would ever waive due diligence, I don't know. Although to be partly fair, I've heard of people doing this in homeowners. This would be the rough equivalent of buying a home by waiving inspection and waiving all other conditions, which, given the housing market in some places, some people are doing shit like this. People are buying homes, sometimes sight unseen, mind you, because of the nature of the market. Sometimes people are buying homes sight unseen at humongous premiums, sometimes 20, 30, 40 or more percent over ask. And sometimes they're doing it saying all cash, waiving all conditions, waiving inspection, waiving everything. I don't think this is a particularly wise idea. I don't really think, I understand you want a home, but do you really want to buy a home waiving everything? And do you really want to buy a $44 billion company waiving everything? I don't know, man. Okay. Okay. The agreement was negotiated throughout the night and in the process became even more seller-friendly. Among the provisions not contained in Musk's proposal but included at Twitter's insistence were an undertaking by all defendants, including Musk, to take or cause to be taken all actions and to do or cause to be done all things necessary, properly or advisable to obtain financing. A clear disclaimer of any finance conditions closing, and a right on Twitter's part to request and promptly receive updates from Musk. Did they put in the actual agreement the waiver of diligence? Because if they did, Musk has massive problems. If they didn't, Musk is probably okay. Because the agreement is going to supersede almost certainly anything else. But let's see what happens. These provisions ensure that financing would be no obstacle to closing and the company with the right to stay informed. Twitter also negotiated for itself a right to hire and fire employees at all levels, including executives, without having to seek Musk's consent. $2 from John O'Brien. Quick claim versus warranty deed. Bar subject. Something like that, yeah. Something like that, yeah. Musk's initial draft of the merger agreement would have him deem the hiring and firing of an employee at the level of vice president or above a presumptive violation of the ordinary course covenant absent Musk's consent. Twitter successfully struck that provision before filing. Twitter further negotiated and narrowed the circumstances under which the defendant could escape the deal by claiming a company material adverse effect. In addition to excluding, for example, market-wide and industry-wide effects and circumstances and declines in stock price and financial performance, the final deal excluded matters relating to or resulting from Musk's identity or communications, performance of the agreement, and any matter disclosed by Twitter and its SEC filings, other than risk factors and forward-looking statements of those disclosures. Okay. So he's disclaiming any reliance on any SEC filing except as it might relate to risk factors and forward-looking statements. Okay. Finally and critically, Twitter negotiated for itself a robust right to demand specific performance of the agreement terms that encompassed the right to compel defendants to close the deal and ensure that Musk personally was bound by that provision. Incidentally, just because it includes specific performance as an express remedy doesn't inherently mean a court will grant it. But obviously it helps because it's a specifically contemplated remedy. So it increases the probability of the remedy. At the board meeting on April the 25th of 2022, Goldman Sachs and JP Morgan each presented their fairness opinions, and the board discussed the agreement. The board ultimately approved the merger agreement and decided to recommend stockholder approval, both because the price was fair to stockholders and because the merger agreement promised a high level of closing certainty. Twitter had taken Musk's claim seller-friendly draft agreement and secured other key concessions to make it even more so. Not only were there no financing or diligence conditions. Okay, well, it'd be helpful if they expressly waived the diligence conditions, but we'll see what the agreement says. But Musk has already secured debt commitments that, together with personal equity commitment, would suffice to fund the purchase. Twitter had been buffeted by Musk's reversals before. For the benefit of stockholders, the board needed assurance the agreement would stick. It received the assurance its terms were able to negotiate. Okay, fine. The terms of the transaction are governed by the merger agreement. Yes, this is also true of contracts in general, right? So a contract is governed by its own four corners. As a typical and pretty solid rule, you don't look to things outside the contract. So what he said or didn't say in various SEC filings is unlikely to be informative except to the extent the contract expressly calls for it. So when you're interpreting contracts, the place you start and often stop is the contract itself. You don't look to outside representation. So it's in the contract or not is your usual go-to rule. Jason says, you've helped me better understand writings and analyze with critical thinking logic. Will you be doing a video on the video released today on the Uvalde school shooting? I don't know if I'll do a video about it, but I have tweeted a copy of the video and it is truly disturbing. I might do a video about it. I mean, I've got a backlog of videos to do, and I've got editing, doing all kinds of stuff. Once I've completed the bar exam, I'll have more time. So things will be a little bit rough for the next 2 weeks. And then after that, I'm going to take a little bit of break. Okay, things will be rough for the next 3 weeks, maybe more. I'll get back to you. The terms of transaction are governed by the merger agreement. Yes, the contract is determined by the contract. Fine. Under the agreement as closing, Acquisition Sub will merge into Twitter, and Twitter will continue as a private corporation owned by Musk through its wholly owned shell companies. Twitter's shareholders receive $54.20 per share, and the company's common stock will be delisted. The conditions closings are few. The transaction is subject to a majority vote of Twitter shareholders and to specific regulatory approvals. The deal is also conditioned on non-occurrence of company material adverse effects that's continuing at the time of closing. This agreement contains various representations by Twitter, including that its SEC filings since January the 1st, 2022, which is like yesterday, basically, at the time filed or at the time amended or supplement are complete and accurate in all respects. Its filing since January 1st, 2022? That's no time at all. Okay. Fairly depict the financial condition of the company in all material respects and were prepared in accordance with general accounting principles. Any inaccuracy in these representations does not excuse closing unless it rises to the level of a company material adverse effect, which is any change, event, effect, or circumstance which individually or in the aggregate has resulted in or would reasonably be expected in to result in a materially adverse effect on the business, financial condition, or results of operation of the company and subsidiaries taken as a whole. John O'Brien says this will be a measuring contest between Watchell and Sackton. Might very well be. As one would expect with seller-friendly merger agreements, the company contract identifies numerous changes, events, and circumstances expressly excluded from these kinds of effects. Okay. Changes, events, effects, or circumstances which directly or indirectly, to the extent they relate to or result from the following, shall be excluded from and not taken into account in determination of an adverse effect. So an adverse effect is any change that would result in a materially adverse effect on the business or results of the corporation. And what's material is, but here are some things that we're not going to consider. Any condition, change, effect, or circumstance generally affecting any of the industries or market in which the company operates. So general industry-wide things, that's not us. General economics, regulatory, or political conditions or changes thereto, or conditions or changes therein in financial, credit, or securities markets, including changes in interest or currency exchange rates in the United States or any other country in the world. Basically, again, things that affect the economy as a whole. The negotiation, execution, announcement, performance, consummation, or existence of this agreement or the transactions contemplated by this agreement, including by reason of their identity of Elon Musk, parent, or any of their affiliates or respective financing sources, or any communication by parent or any of its affiliates or respective financing sources, including regarding their plans or intentions with respect to conduct of the company or any of its subsidiaries. So basically, anything that you, Elon Musk, or any of the people backing you say that might hurt us, that's on you, which, fair enough. Any litigation, claim, or legal proceeding threatened by or initiated against parent, acquisition sub, the company, or any of the respective affiliates, in each case arising out of or relating to this agreement or transactions contemplated by this agreement, including any impact with that. So basically, anything that is completely external to Twitter and anything that you cause yourself, which makes total logical sense and sort of exclusions, right? It's only things that are somehow unique to Twitter or Twitter self-inflicts. If Elon Musk says it, that's on you. RN Rules gives $19.99. I truly enjoy your content. Thanks for taking the time to produce it. You're welcome. Thank you for taking the time to enjoy it with me. I'm really happy that you're here. Any change in the market price or trading volume of the stock, any failure by the company or subsidiaries to meet internal analysis or other earnings estimates or financial projections and forecasts for any period, any change in credit ratings or any changes in analysis recommendations or ratings, provide the facts or occurrence that give rise to it are not otherwise excluded. So basically, again, external people are going to do what they do. So if someone says buy or sell, that's not on us. Fair. Any matter disclosed in the company's SEC documents filed by the company prior to the date of this agreement, other than any disclosure set forth in the headings, risk factors, or forward-looking statements. So we're going to disclaim, anything that is in the SEC statements other than that might be set forth in the risk factors or forward-looking statements. Fine. The parties thus agreed that any circumstances affecting the market generally or other social media companies would be excluded. That's basically what it says, yeah. Anything that is industry-wide, anything that's financial system-wide, anything that's monetary-wide, monetary changes of policy, anything that Elon Musk or anyone associated with him does to negatively impact the value. If you want to negatively impact the value, it's kind of on you, hurting the value of the thing. So that all makes logical sense. Nor would any circumstance arising from the existence or performance of the agreement or any communication by Musk, including impact of any of the foregoing or any Twitter's relationships with, among others, customers. Likewise, matters disclosed in sections of the SEC filing other than risk factors or forward-looking cannot constitute a material effect. Fine. Andrew James, 750. Kurt's the only source I found actually going through the complaint. Keep following this case. I'm going to try. We'll see how it goes. I'm open-minded, and I don't really favor either side on this. I'm in favor of the law, and in favor of the contract, and in favor of what the parties agreed to. So, we'll see what they agreed to, but these provisions all sound fine, normal, reasonable. Not so much with the waiver of diligence, but if Elon Musk was stupid enough to do that, I'm certainly not going to protect him. He's a sophisticated party. If this were just someone buying something in a store, then I'd feel a lot differently about it, but it's not. He's a sophisticated party, so yeah, he's kind of on the hook for that one. Or it could be, depending on the nature of the contract. We'll see. Twitter's failure to meet financial projections will not exclude closing unless the failure results from an occurrence independently qualifying. The agreement also makes clear financing is not a condition. Notwithstanding anything contained in the agreement to the contrary, the equity investor, parent, and acquisition sub each acknowledge and affirm that it's not a condition to the clothing or any of its obligation under this agreement that the equity investor, parent, acquisition sub, and or any of their respective affiliates obtain financing. So your ability to get financing or not is irrelevant to this deal. Okie dokie. Nor is there any diligence condition. Indeed, each apparent and acquisition sub represents that it conducted to its satisfaction its own independent investigation, review, and analysis of the business, record, results of operations, prospects, condition, or assets of the company and subsidiaries, and determining to proceed with the merger, each relied solely on the results of its own independent review, analysis, and covenants, representations, and warranties of the company in the merger agreement. Parent and acquisition further acknowledge that neither the company nor any of its subsidiaries, nor any other person makes or has made or is making any other warranty with respect to the business other than what's in the contract. Yeah, this is just like standard contract law at this point to some degree. T in Tennessee says, I agree with you as you explain as you go. Well, thank you very much. I appreciate that you explain as you go. You're welcome very much. So some of this is kind of just standard contract law, and some of it's kind of like true whether or not the contract says it. For example, like you've made no other representations other than what's in the contract. Right, the contract is what governs. This is a standard principle of contract law 101. Right? The contract is what matters. What matters is in the contract. It doesn't matter what you guys said in advance of the contract. Doesn't matter what handshake agreements you had. Doesn't matter what you said to each other. What matters is in the contract. If it mattered, put it in the contract. If it didn't matter, well, okay, whatever. Brianna said, you're good at Kurt. Thank you. I'm so grateful to you for all your videos you've been making for us. I would have lost my voice weeks ago. No problem. I've got some tea, and I've got plenty of voice left to share. So, fine. And also that you basically have acknowledged that you've done your own due diligence. Okay. And you're happy. Okay, this seems reasonable. So far, so good for Twitter. No other representations other than what's made. Standard contract law principles, so fine. The agreement requires all parties, including Musk, to use their reasonable best efforts to consummate the merger and cause all closing conditions to be satisfied. Good faith and fair dealing. Basic principles. That's fine. Defendant, including Musk, have a hell or high water obligation to close. They must take or cause to be taken all actions and do or cause to be done all things necessary, proper, or advisable to arrange, obtain, and consummate the financing at or prior to closing on terms and subject to conditions set forth in financing commitments. So this is a bit of a pet peeve, because hell or high water is actually something that has legal effect in contracts in some parts of the United States, and I've seen it happen. So a hell or high water. So one of the things that you can do to get out of a contract is impossibility of performance, right? Impossibility of performance. I'll give you an idea of what I mean. All right. Let's say that I am building a house, and one of the things I'm going to need for my house is some windows. And my house uses lots of windows. It's a big house and has lots of windows. So one of the things I might do, maybe I'm the general contractor or whatever, it doesn't matter who I am in this equation, but I'm going to contract for some windows, right? I'm going to say I need, 100 windows, then I need them to be these sizes, and I need them delivered on this date, and blah, 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 right? So we have a contract for the windows, delivery on this date, for the house that I'm building. Now, what happens in the meantime if the house burns down? Right? Because we're building it, right? The windows aren't going to be needed until the house is in a condition to accept windows. So it's a relatively late add to the project. So what happens in the meantime if the house burns down? Well, one of the things you can try is called doctrine of impossibility of performance, right? This doesn't make any sense anymore, right? I can't, or I'll even do one better. The contract is not only for the delivery of the windows, the contract is specifically for the installation of the windows, right? So let's say the contract says, okay, we'll make it one better. Let's say the contract says, I'm going to deliver and install these windows in the house that you've designed. And the design of the house is included in the contract, right? It's included as an exhibit. So like the blueprints are included. So we know exactly what we're talking about, okay? So the contract says, I'm going to deliver to you, and I'm going to install in this house that you're constructing, according to this design. I'm going to deliver and install personally these windows myself, and upon completion of installing the windows, I get paid. Okay, this is what it says. All right. So I have this deal with the general contractor. General contractor, orders the windows, and the deal is when I install them, I get paid. Great. All right, so what happens in the meantime if the house burns down? Well, one of the things you can try is doctrine of impossible performance, right? I can't perform anymore because there's no house for me to install the windows into, right? Because it burned down. So there's impossibility of performance. So it's like the general contractor calls me and says, we don't need those windows anymore. We are not going to need them installed. Sorry about everything, but too bad, so sad. This could potentially work as an excuse, a legal excuse, impossibility of performance. Now, I've actually seen it done where in a contract, someone puts in literally a hell or high water provision. And they literally use those languages. Okay? So, let's say that, let's say there is a hell or high water provision. And the contractor says, geez, the house is burned down, the project is ruined. The building site, incidentally, wasn't insured because, I don't know, don't ask reasons. The building site wasn't insured, and the people that built it don't have any money left. They've fled to Cuba or dead or whatever, right? So there's no money left, and there was no insurance, so there's no money there. And also, I don't know, earthquake or whatever, I don't care, right? Now, let's say for whatever reason, I'm the company that wants to the windows, and let's say this is a really good deal for me. This is a really good deal for me. So if there's a hell or high water provision in that contract, in some states, that's a legally operative provision. So what I can do is say, doctrine of impossibility, I don't know what you're talking about. You better build that house. You better find a way. Because I have a contract to deliver and install those windows in a house that meets these specifications. You better figure it out. But I don't have any money. The people that owned it are dead and they fled the country, and it turned out it was all fraudulent money, and the house wasn't insured, and there isn't anything. It's like, well, sucks to be you, I guess. I don't know what to tell you. You're going to have to build that house anyway. And in those states, courts would enforce that agreement. It's a waiver to doctrine of impossibility. So one of the reasons I get a little frustrated is because it's like when you say, oh, there's a hell or high water provision, I'm like, holy shit. When you say that in some contracts, that has some legally operative effects. So you might want to watch out for that kind of thing. Taylor Lynn says $20. Thank you very much for your sticker. And John O'Brien gives $5. Opera singer signs a contract for performance at a theater. The theater burns down between contract and performance. Well, your example doesn't work because it's a personal services contract. I do appreciate your effort, but you can't. Well, if the opera singer is the one insisting, then you're there. So yes, you must build the theater for me to sing. So if the opera singer is the one trying to insist on the contract performance, you're there. If the theater is the one trying to insist on the performance, you can't get specific performance in a personal services contract. See the 13th Amendment about that one. So, but I appreciate your enthusiasm anyway. Carrying on. The merger agreement requires the parties to share certain information with another in the run-up to closing. Defendants, including Musk, are required to keep Twitter reasonably informed on a current basis of the status of their efforts to arrange and finalize the financing, and provide and respond to any updates reasonably requested by the company with respect to its status. For its part, Twitter is required to use commercially reasonable best efforts to assist defendants with arranging and financing, but the obligation is qualified. Twitter need not prepare or provide any financial statements or other financial information other than financial information provided to the SEC, nor provide any other information that's not available to the company without undue effort or expense. What is undue? One wonders immediately. Moreover, Twitter's obligations under the law are its sole obligations with respect to cooperation in arrangement of financing, and Twitter may be considered to have breached the provision only if failure by parent, and that's Elon Musk, to obtain the committed debt financing is due solely to a deliberate action or omission taken or omitted or taken by the company in material breach. So basically, you can only breach, at least according to Twitter, if we fuck it up. Okay. Subject to certain conditions, including entry into a confidentiality agreement, Twitter must provide parent and its advisors with reasonable access to information about its business, properties, and personnel as defendants reasonably request. What is reasonable is very much in the eye of the beholder. The information requested must be for a reasonable business purpose related to consummation of the transactions contemplated by this agreement. Well, what is going to be reasonable related to the consummation of the transactions contemplated goes a lot to the nature of the agreement. Because if Elon Musk is waiving a whole bunch of things and has waived diligence and basically said, I've done all my due diligence in advance, then like what information is really relevant? Not much. So the nature of what is relevant for the purpose of consummation is going to be heavily dictated by the nature of the contract. But so far, at least, Twitter is making a good case. I don't know if they've attached a copy of the actual contract at this point or not, but if they have, maybe we'll read it and we'll see if we can deduce what we think in terms of whose obligations are what. In addition, Twitter can decline a request if in its reasonable judgment it determines compliance would cause significant competitive harm to the company or subsidiaries if the transaction contemplated by agreement are not consummated or will violate law, including privacy law. Since this is all supposed to be done within the specific context of a non-disclosure agreement, I'm not even 100% sure what that could be, but okay. Parent cannot use the information obtained for any competitive or other purpose unrelated to consummation. Fair. And parent must use reasonable best efforts to minimize any disruption to Twitter that may result from access. Also fair, right? You can't interfere with our business you're trying to buy until it's yours. Seems fairly reasonable, all things considered. Seems reasonable, all things considered, but you know. The agreement contains a seller-friendly ordinary course covenant requiring Twitter to use no more than commercially reasonable efforts to conduct the business of the company and subsidiaries in the ordinary course of business unless other things in action outside ordinary course is agreed to writing. Okay, fair, fine. John says, offering a classic impossibility hypo, one again. No worries, Jonathan, you're all doing fine. Or John, you're doing fine. There's no requirement of compliance with past practice. Fair. And as noted before the agreement was signed, Twitter succeeded in striking from the covenant or retirement to obtain consent for hiring and firing of employees. As long as that would be done in the ordinary course of normal business, fine. That's fine. Section 6.8 of the agreement contains standard language requiring each side to consult with the other before issuing certain public statements, as well as negotiated language concerning Musk's ability to tweet about the merger. Under the provision, Musk may so tweet only as long as such tweets do not disparage the company or any of its representatives. Well, what it means to disparage, again, is a little bit in the eye of the beholder, so we'll keep pressing on. Defendant's ability to terminate the agreement before the presumptive drop-dead date of October 24th is extremely limited and carefully circumscribed. While there are closing conditions related to accuracy of Twitter's representations and warranties, and at some point I hope someone's going to tell me what those are, and Twitter's compliance with its covenants, there's no right defendants to terminate unless there's a breach sufficiently significant to cause failure of the closing condition, which after due notice is either incapable of being cured or not cured within 30 days. Defendants have no right to terminate, moreover, if any of them are in material breach of their own obligations of the agreement, which is fairly typical in contracts, right? You can't obviously breach an agreement to get out of an agreement. It's like, oh, the contract's in breach. Yeah, but you're the one causing it. You know, that doesn't work. That's how we can sue you. That's us getting out, not you. Okay. Yeah, that's fine, Genome. I got it. It's fine. Twitter may seek specific performance, an injunction, or other equitable relief to enforce any defense obligation on the merger. Okay, apparently there's a provision for this. It has a specific power to compel Musk to fund the equity financing and close the merger, provided the closing conditions are met or capable of being met. The debt financing, which is already committed, has or will be funded, and the company is prepared to close. At the time of signing, the financing for the transaction had three components: loans to the post-closing Twitter, a personal loan on margin to Musk against Tesla stock, and an equity commitment for Musk himself. Loans to Twitter, I'm not sure why it matters to Twitter one way or another, incidentally, because he's obligated regardless of financing. That was one of the things. So I'm not really 100% sure why it matters, the degree to which the degree to which Musk had financing lined up or not, or changed the financing or not, because the agreement just seems to contemplate Musk, you have to come up with $44 billion from somewhere. So all right. The committing financing comprises a $6.5 billion loan, $500 million of revolving credit, and $6 billion of bridge financing. Although the debt commitment layer requires Musk to assist the lenders in marketing the debt, his failure to do so does not release the lenders from their obligation to fund, and the financing is not commissioned on their ability to buy. That does seem to be true, based on what Twitter says at least. The lender's obligation is subject only to the closing of the merger itself, and certain other conditions the satisfaction of which lies in defendant's control. If defendant is the one responsible for breaching this, defendant cannot claim the benefit of his own bad action. The margin loan of $12.5 billion of Musk personally was promised by Morgan Stanley and other lenders. The loan was secured by $65 billion of stock, about 62 million shares. I'm not sure why it matters one way or another, but fine. Under the equity commitment letter, Musk also personally agrees to contribute. Again, I'm not sure why it matters. I'm just going to skip that. The risk of market decline, which was Musk's alone to bear under the merger agreement, materialized. I mean, that does seem to be true, right? There's going to be some period between the time which you agree to buy the thing and the thing being bought. The price could go up, the price could go down. I mean, the value of the thing rather than the price, because the price is fixed by the contract. The value could go up and the value could go down. The risk of the value changing is borne out by both parties. If it goes up, it benefits one party. If it goes down, it benefits the other. It's one of the risks if you have some gap, absent language in the contrary and the contract to the contrary, which of course can shift that agreement or that risk. Orgborg gave $5 to say, wow, you're welcome. And as long as we're talking about fonts, I kind of like Garamond, but it's just me. Garamond. He then promptly tweeted no further Tesla sales today, but Tesla stock kept dropping, putting Musk at risk of needing to pledge yet more shares to consummate his proposed margin loan and still sell more to fund his equity commitment. On May the 4th of 2022, Parent and Musk, faced with needing to pledge more Tesla shares to satisfy the loan, dispensed with the loan entirely and agreed on a new equity commitment layer. Again, I'm not sure why. Not sure why Twitter cares one way or another. That letter remains operative, gives Twitter third-party beneficiary rights to enforce directly against Musk his equity commitment in accordance with new terms and a new merger agreement. Fun times. Musk remains personally responsible for the $33.5 billion of approximately 44. Okay. Musk wanted an escape. Back to the dramatic reading. But merger agreement left him little room. With no financing contingency or diligence condition, the agreement gave Musk no out absent a company material adverse effect or material covenant breach. Musk has tried to conjure those. Ooh, fun and exciting. What Musk alighted, great word choice. I'm not sure it's 100% appropriate in this sentence, but I do like it anyway. What Musk alighted upon first was representation in Twitter's quarterly SEC filings over many consecutive years that, based on internal processes, the company estimated the average or false spam accounts on its platform represented fewer than 5% of our daily average. Now, is this language in the sections that are binding? I'm going to assume so because Twitter didn't tell me any different. We'll have to watch a video after this, which tangentially deals with fonts. Anyways, okay. Twitter employs to measure the number of people or organizations that use the Twitter platform. In its filings, Twitter defines the daily users as people, organizations, or other accounts who are logged in or otherwise authenticated and access Twitter on any given day. So daily users means daily users, fine. In addition to deploying automated and manual process that suspend on average 1 million accounts every day, the company undertakes a rigorous daily process using human reviewers to estimate spam or false accounts remaining on its platform after automated filtering and manual review. You want a font poll? Okay, hold on. All right, so then I'm creating the poll. Let's see, font. Let's say best font. Okay, hold on. I get my this is my pulse and my choices. Okay. So Garamond is going to be 1. So I really like it. And we'll do Lex End, which is a very highly readable font. We're going to do Arial's kick-ass. And what should we do for a 5th one or 4th one? Times? You want to go Times, old school? Times New Roman? All right, so Garamond, Lexand, Arial, and Times New Roman. Go. Readable, why would that be important? For a font? To the 389 of you who are currently watching, thank you. You're only allowed 4 options, so we did the best we could. All right. We could have a font bracket, elimination bracket. That could be fun. Trying to decide what the best font is. We could put the fonts up on screen. This will be a test poll, and if you guys respond well to this, we'll have a stream where we go over fonts, and we can pick the fonts for the channel and for the branding. All right. Twitter's SEC's disclosures regarding the process and findings are heavily qualified. As described in the note regarding key metrics section of the filings, Twitter's calculation of daily users is not based on any standardized industry methodology, may differ from estimates published by third parties or from similarly titled metrics of our competitors, and may not accurately reflect the number of actual people or organizations using our platform. Yeah, that last one I have a problem with. I don't think you can disclaim your way out of, like, the numbers existence. You can't, I mean, may not accurately might allow for a little bit of leeway, but it's not going to allow you to basically like this number's made up. I don't think so. As estimate of spam or false accounts as a percentage of daily users, Twitter explains it's based on internal review of sample accounts, involves significant judgments, may not accurately represent the number of actual fake or spam accounts, and could be too low. One will take note that could be too low is not in quote marks for whatever it's worth. Twitter has published the same qualified estimate, fewer than 5% of daily users are spam or false, for the last 3 years. Well, it doesn't mean it was true in any of those years, but okay. Musk was well aware when he signed the merger agreement that spam account for some portion of the daily users, and was well aware of Twitter's qualifying disclosures. The qualifying disclosures are only going to get you so far. Spam was one of the main reasons Musk cited publicly and privately for wanting to buy the company. On April the 9th of 2022, the day Musk said he wanted to buy Twitter rather than join its board, he texted Taylor for purging fake users from the platform had to be done in the context of a private company because he believed it would make the numbers look terrible. One can parse that two different ways, by the way. The purging of the numbers would make the platform look terrible, or the not purging would make the platform look terrible. That sentence is not well written because it could be read either way. At the public event on April the 14th, Musk said in eliminating spam bots would be a top priority for him in running Twitter. On April 21st, days before the deal was inked, he declared, "If our Twitter bid succeeds, we will defeat spam bots or die trying." So we're gonna basically say that we knew this risk and accepted it. Bree Hanna said, though I think most accounts on Twitter are tied to real people. There's no way that under 3% nonsense is accurate. No one believes that. Yeah, apparently something like 28% of the accounts following me are spam, and I don't know why. But at least according to one analytic I saw, so I was like, well, that's interesting. Apparently like 15% is the average. So I'm not sure why I've got fake accounts following me, but okay. Musk echoed the same sentiment in the press release announcing the merger on April 25th, stating that upon opening Twitter, he would prioritize defeating the spam bots and authenticating all humans. Yet Musk made his offer without seeking any representation from Twitter regarding its estimates of spam or fake accounts. He even sweetened his offer to the Twitter board by expressly withdrawing his prior diligence condition. Yeah, but he did that in a letter that's outside the agreement, so I'm not sure it matters. On May the 5th of 2022, Musk announced he had raised an additional $7.1 billion in equity. I don't really care that much. Musk made his plans to address spam a key part of the pitch. As the co-CEO stated in publicly announcing the investment, the firm thought Musk was perhaps the only person in the world who could fix the allegedly difficult issue with bots. Then, however, as market and Tesla's stock price declined, Musk advisors began demanding detailed information about Twitter's method of calculating daily users and estimating the prevalence of fake or spam accounts. Okay. Twitter had entered into a confidentiality agreement with Musk to share non-public information in preparation for public closing transition, and conveyed an in-person meeting with Musk and his team on May the 6th of 2022. Among the topics discussed were daily users and spam-related subjects. In advance of the meeting, Musk's bankers circulated an agenda with items related to users on the platform, including how do you estimate that fewer than 5% of daily users are false or spam? Twitter's representatives addressed the question of the meeting, summarizing the company's process. Following up that, on May the 9th, Musk's bankers at Morgan Stanley added entries to their diligence tracker requesting user-related information, including a request for user database containing key metrics, including but not limited to number of users, number of verified users, number of monthly active users, number of handles, etc. So, all right. So this goes into whether or not this is a potentially legitimate business reason relating to the consummation of the merger. Right? If Musk basically waived all the issues with financing and basically said, financing is a total non-issue, then his backer is getting, cold feet for whatever reason is irrelevant because he's waived all that. If not, then it is more relevant because his backers want to know. So one of the things that might determine whether or not, and to the degree, this is reasonable information relating to the consummation of the agreement is the degree to which Musk did or did not, waive issues relating to financing. So, but even if he waived it relating to financing, it could still be relevant because it's relevant to his business need. It's not relevant to the deal with Twitter, but still relevant to his business need. So it's still businessly relevant. So I guess you can make an argument either way. It would just change the nature of the argument and would change the likelihood of the argument. Neither Musk nor his advisors said what prompted these requests or identified new information regarding spam or false accounts that come to light warranting the inquiries. I don't know. Maybe they were looking more into it and they got, they did their due diligence and they were just like, things don't make sense. Nothing had changed about Twitter's estimates concerning the prevalence of spam on the platform. I'm not sure we trust your estimates, but okay. No one likes Lexand. Fine. How are we doing? 37% on Twitter, or 37% on Times, 31% on Ariel, 27% on Garamond, 5% on Lexand. Garamond is objectively the best. Yeah, I mean, I tend to think that's right. Okay. Early on May the 13th of 2022, in advance of a diligence meeting that had been scheduled to discuss the data Twitter had provided, Musk tweeted without any advance notice, he's not required to, the company that the Twitter deal is temporarily on hold until the company can show him proof for its estimate that less than 5% of Twitter accounts are fake or spam. Yeah, he probably doesn't have the ability to do that. The Reuters story Musk linked to his tweet was a report of Twitter's 10Q filing made on May the 2nd, 2022, and containing the same heavily qualified 5% estimate they disclosed for the SEC for years. Well, heavily disclaimed, or heavily qualified, I mean, it's still got to mean something. Two hours after the on-hold tweet was published, Musk belatedly, 2 hours later is not that belatedly, tweeted that he was still committed to the deal. Cognizant of its own obligations under the merger agreement, Twitter proceeded with the May 13th diligence meeting, which lasted for 2 hours. During the session, Twitter explained, among other things, its spam estimation process entails daily sampling for a total set of approximately 9,000 accounts per quarter that are manually reviewed. 9,000 accounts per quarter are manually reviewed? 9,000 accounts per quarter. That's 100 accounts a day. Depending on what we mean by manually reviewed, that is well within the capacity of one person. $9,000 accounts are reviewed manually every quarter? That's nothing. That's nothing. A guy could do that, depending on what we mean by manual review. I mean, if they spend only a couple minutes per, you're there. And if you have a 10-hour workday, that's 10 an hour. That's one every 6 minutes. If you do a 5-day, if you do every day of the week, if you do it 5 days a week, I'd have to do the math, but it's probably, and you did an 8-hour day, it's probably something on the line of it's a couple minutes. It's like 3-4 minutes, something like that. So that's nothing. One guy could do that. Later that day, Musk publicly publicized a misrepresentation. The sample size was $100. Well, 100. Per day, yeah, it kind of is. To find out, my team will do a random sample of 100 followers on Twitter. I invite others to repeat the same process and see what they discover. Any sensible random sampling process is fine, and many people independently gain several results for the percentage of fake spam accounts that I'll be telling. I picked 100 as a sample because that's what Twitter uses. I mean, on a per-day basis, that's kind of like, yeah, what it is. Yeah. The next day, he boasted publicly that he violated his non-disclosure. That's not what that says. Twitter legal just called me a complaint I violated their NDA. That's not him saying I violated the NDA. That's him saying you called me to say I violated the NDA, which are not the same thing. Musk's tweet on May the 13th and 14th violated his obligations under the merger, including provisions prohibiting public comments not consented to, but he's allowed to tweet, as long as it doesn't disparage. And then we're into what disparagement is. On May the 16th, on May the 16th, the CEO tweeted that the Twitter estimate is based on multiple human reviews and replicate for thousands of accounts that are sampled at random constantly over time from accounts we count as part of our daily users. He explained the company human review process uses both public and private data to make determination on each account, something Twitter also explained in its SEC filings. The CEO stood by Twitter's estimate and noted the company is constantly updating a system and rules to remove as much spam as possible. Fine. Musk responded with another disparaging tweet, which is just a poop emoji. As the market continued to fall, Musk persisted in public and misleading attacks on Twitter's handling and disclosure of the spam and fake accounts. Okay. Interesting, I suppose. Where was I? Sorry, I got distracted for a second. As the market continued to fall, Musk persisted in public and misleading attacks on Twitter handling and disclosure of spam or fake accounts. In our tweet on May the 15th, 2022, in a statement of technology conference on May the 16th, Musk made baseless claims that fake users might account for as much as 90% of Twitter users. Asked whether Twitter deal is going to get closed, Musk responded, it really depends on a lot of factors, and posited that Twitter's estimate of spam and false accounts comprising fewer than 5% of daily users might be a materially adverse misstatement if it's in fact 4 or 5 times that number, or perhaps 10 times, when we'll take note that 5 times 5% is still not 90%, so one wonders where he came up with the 90% number. On May the 17th of 2022, Musk tweeted without basis or explanation that 20% fake spam accounts, while 4 times what Twitter claims, could be much higher. I mean, where is he cutting this from? Adding that the deal cannot move forward pending further analysis. I'm not saying he's wrong. I'm just curious how he's generating this. Which, pending further analysis. And yet another breach of non-disparagement obligations. Musk encouraged the SEC to investigate. Is that disparagement? I don't know. Even as Musk was violating his own contractual obligations, Twitter continued to respond cooperatively to representatives' increasingly unreasonable inquiries. Between May the 16th and May the 20th, the company provided detailed written responses to several information requests. On May the 20th of 2022, Musk's team sent a request for Twitter's Firehose data, exciting, which essentially is a live feed of all the data concerning Twitter. I kind of got that from the analogy. I picked up on that. Yeah. Again, no explanation was offered for how this request furthered a reasonable business purpose related to consummation of transactions contemplated by. Depending on the nature of the agreement, they might be right. Nor can Firehose defense data even be used to accurately estimate the prevalence of spam or fake accounts. That seems dubious to me, to be honest. As the CEO explained in his May the 16th tweet, the estimate depends on part of private data not available in the Firehouse. Conversely, Firehouse includes tweet systems that do not count within his daily use. On May the 21st, Twitter hosted a third diligence session with Musk and again disclosed Twitter's process for calculating the daily use and the spam. Twitter also provided a detailed summary document describing the process the company uses to estimate spam as a percentage of the daily users. Defendant responded with increasingly invasive and unreasonable requests, and rather than use reasonable best efforts to minimize any disruption, to respective business of the company and subsidiaries that might result from requests for access, defendants repeatedly demanded immediate responses to their access requests. The scope of the requests and deadlines imposed were unreasonable, disruptive, and far outside the bounds of Section 6.4. We'll need further evidence to demonstrate that. Twitter nonetheless continued to work with Musk to try to respond. It extended an ongoing offer to engage with Musk and his representatives regarding calculation of daily users, and held several more diligence sessions throughout the end of May. It also provided detailed written responses, including custom reporting, to its escalating requests for information. Well, we'll need further evidence about that for sure. On May the 25th of 2022, defendants' counsel sent the first of a series of aggressive letters copying the litigation counsel at Quinn Emanuel. Now, that's always a good sign. When you start copying legal counsel, you know things are going super well. This one falsely asserted that Twitter had failed to respond to any of the defendants' information requests, and insists defendants be granted access to the Firehose data so Musk could make an independent assessment of the prevalence of fake or spam accounts on the platform. Though the letter called Twitter own spam detection methodologies lax, which, given their description, yes, it identified no basis. Well, if you're reviewing about 100 accounts a day manually, yeah. Nor, again, did defendants explain how fulfillment of Firehose data demand would further consummation of the merger, or what basis they had to demand the right to make an independent assessment of the prevalence of false or spam accounts on the platform. Even assuming it was a proper purpose, reviewing the full Firehose data would not result in an accurate assessment or mimic the rigorous process that Twitter employs by sampling accounts and using public and private data to manually determine whether an account constitutes spam, as Twitter's representative had already repeatedly explained to Musk's team. Again, I'm not 100% sure about that. I think if you had access to all the data coming in, you might very, very well able to do some correlative analysis regarding what spam accounts are. Who tweets when, related to who. If a bunch of accounts are always tweeting near each other, they might be related accounts, it might be spam. If they're all tweeting the same things, it might be spam. I think you could do some interesting analysis based on the Firehose data. That would be potentially viable, could make sense. Could potentially make sense. Nor again did defendants explain how fulfillment of the Firehose data would further their consummation of the merger, or what basis they had to demand to make an independent assessment of prevalence of false or spam accounts on the platform. This again is going to go to the nature of the contract. What does the contract provide for in terms of what is he allowed to know, and what representations are he making? This is all very, very contract dependent. So hopefully at some point someone, let me just see real fast. Hold on. I'm on page 37 and 62. Is someone going to give me a copy of the contract? No, they're not. Well, that's disappointing. If anyone happens to have a copy of the actual contract these guys signed, if they could email it to me at uncivillawYT@gmail.com. It's in Discord. Is this a copy of the contract, the SEC thing? Form 8K? April 25th, 2022? I'm so confused by this. Is this the actual agreement, or is this just a summary of the agreement? I think that's just a summary of the agreement from the SEC. Is that all we have? Yeah. A copy of which is filed as Exhibit 2.1 and incorporated by reference herein. Where is Exhibit 2.1? It's not hyperlinked. It is omitted. So we don't have it. Or do we have it? Agreement plan and version. Oh, we do have it. Executed version. Oh, okay. So it is here. Okay. This is going to take some time to go through. This is going to take a lot of time to go through. Well, let me make a copy of this. And I'll try to go through this at some point in the future. Hold on. Okay. All right, back to this thing. It's going to take some time to get through. All right, let's carry on. From the outset of the extraordinary post-signing information exchange process, Musk has accused Twitter of lax methodologies for calculating spam or fake accounts. Knowing his actions risked harm to Twitter, and thank you, by the way, for the 411 of you who are currently watching. It's very, very validating, by the way. If you haven't subscribed already, if you could hit that subscribe button, it would be nice. Knowing his actions risked harm to Twitter and stockholders, wreaked havoc on the trading price of Twitter stock, and could have serious consequence for the deal, Musk leveled serious charges both publicly and through his lawyers that Twitter had misled investors and customers. But Musk exhibited little interest in understanding Twitter's process for estimating spam accounts that went into the company disclosures. Indeed, in a June 30th conversation, Musk acknowledged he had not read the detailed summary of the sampling process provided back for in May. Once again, they offered to spend time with Musk and review the detailed summary of the sampling process. As the Twitter team had done with Musk's advisors, that meeting never occurred despite multiple attempts from Twitter. From the outset, the defendant's information requests were designed to try and tank the deal. That's assuming a lot of bad faith, which, Musk's increasingly outlandish requests reflected not a genuine examination of the process, but a litigation-driven campaign to try and create a record of non-cooperation on Twitter's part. I mean, I don't know how you're going to prove that, but okay. When Twitter nevertheless bent over backwards to address increasingly burdensome response, Musk resorted to fake accusations it had not. Okay. In seeking to manufacture a record of covenant breaches, Musk seized not just on Section 6.4, but also 6.11, which obligates Twitter to reasonably cooperate with parent to facilitate arrangement of debt financing. Okay. Which would be part of the reason, incidentally, if they are required to cooperate in helping with the debt financing, that'd be part of the reason they might have to give information to Musk for that purpose. Throughout the post-signing period, Twitter's advisors have been working with Musk representatives to furnish them relevant financial information about the company. These discussions have been productive under the supervision of Musk's side of Bob Swan, a respected Silicon Valley financial professional and former CEO of Intel. Swan had been in regular contact and had been leading defendants' purported efforts to consummate the deal. Then, in June the 17th, lawyer lever, Musk demanded a collection of financial information he claimed was necessary to better understand the state of Twitter's business and outlook, which is related to his acquisition plans and financing. He demanded a working bottom-up financial model for 2022, budget plans with underlying modeling, and a working copy of Goldman Sachs' valuation model underlying its fairness opinion. Okay, that last part might be reasonable. This demand is extremely unusual in merger transactions, and neither in conveying the demand nor any time since have defendants pointed to a request from any lender that would justify it. Notably, Musk's debt financing commitments are not conditioned on receipt of any financial information about Twitter other than that contained in its quarterly filings. Around the same time as the request, on June the 21st, 2022, Musk falsely represented in a Bloomberg interview that an item requiring resolution before the transaction can complete is will the debt portion of the round come together. As Musk well knew, financing is not a condition. That sounds, correct, based on what they're saying at least. It's consistent. Still intent on facilitating the merger, Twitter provided Musk with significant support, detail for its proxy cause projections, shared some of its financial plans, and gave him a copy of the banker's final presentation to the Twitter board. Consuming a merger agreement involves substantial effort and requires serious deployment of resources by the seller. Yes. Defendants thus are subject to contractual obligations requiring them to take actions necessary to close and allow Twitter to operate efficiently as possible. Defendants violated two important obligations. Okay, so we're going to say so now we're going to go into what breaches they made. We'll just skim this part because it's a little less interesting. Abandoning financing relation efforts and breach of section. So, yeah, abandoning the efforts to close. Twitter repeated requests for contact in lieu of Swan. Outreach to Goldman Sachs, faced with uncertainty. Twitter exercises right under 6.10D of the merger agreement to formally seek information about the status of financing. On June the 30th, Musk informed Siegel that replacement team member would be taking over the financing, but never appeared. Musk delays and stymies key operations. Twitter's complied in all respects with the obligation of 6.1 to operate business in an ordinary course. Arguable, but okay. In an exercise of caution, the company they're still banning people for the wrong thing, so there's that. In an exercise of caution, the company has sought Musk's consent even for matters falling within the zone of commercial reasonableness. Though Musk has approved some of these requests, he's been slow to respond to ones that required urgency and unreasonably withheld his consent to others. Most notably, Musk has unreasonably withheld consent to two employee retention programs designed to keep top talent during the period of intense uncertainty. Okay. Excuse me, as my eye decides to act up, which happens sometimes. During negotiation of the merger agreement, Twitter had sought Musk's consent for a broad retention plan. During the post-signing diligence center, Twitter management again broached the subject of retention, and Musk was non-committal. Musk initially failed to respond to all the June 20th consent requests. Following further stonewalling from Musk, Twitter urged a discussion that would be fruitful. Defendants have unreasonably withheld consent on their domains as well. Defendants purport to terminate the merger agreement. Twitter has provided defendants far more information than they're entitled to. Section 6.4 serves a narrow purpose of giving parent reasonable access to information necessary to close the merger. It does not give defendants a broad right to conduct post-signing due diligence of a kind that is specifically forswore pre-signing. Yeah, but no one cares about that because we only care about the four corners of the document. Much less does it give Musk the right to hunt for evidence supporting a bogus misrepresentation theory tried to develop to deploy the deal. Twitter's bent over backwards to provide Musk the information he sought, including the full Firehose dataset that he's been mining. So they gave him access to the full Firehose data. Kind of interesting. Their termination notice, defendants list categories of information they claim Twitter has withheld. Much of the information does not exist, been provided, or subject to request only reasonably. Twitter's cooperation obligation is 6.11. The company has gone beyond what's required. Twitter is not obligated to provide financial information not already in existence or provide copies of a banker's valuation models which are outside the company's control. You could ask. Even so, in response to requests for defendants lodged for the first time, Twitter made the extraordinary ask of its bankers to give Musk the financial board deck they used. It furnished him with other financial information. So you can ask, and did ask, apparently. Nor can defendants show Twitter has made any misrepresentations or collection of representations, the inaccuracy of which is likely to result in an adverse effect. They do not even try. Notwithstanding that defendants have received mounds of information regarding Twitter's processes far beyond they're entitled. The termination notice asserts only preliminary analysis by Musk of the data set causes Musk to strongly believe the reported estimates have been accurate. Twitter did not breach ordinary course covenant. Having materially breached the merger agreement, defendants are contractually barred for terminating. Musk keeps violating and confirms his earlier violations. Damn. My eye. Musk once again publicly called for the SEC to investigate. Musk's conduct simply confirms he wants to escape the binding contract, face irreparable harm. Cause of action, specific performance. And therefore we want specific performance. Well, that kind of brings us to the end of that. So, a lot depends on the specific language of the agreement, as you would expect. This is a breach of contract. And so a lot is going to depend, obviously, on the specific contract. The contract kind of sets up its own law of the case, as it were. What am I looking for right now? All right, we're going to take a very quick look at this. I'm not sure how much energy we have, but we're going to give it a shot. Representations and warranties by the company. There's a lot here. Conditions to the merger. Termination. It's a 71-page contract. It's not, like, absurd, obviously. Defined terms. Put the merger in stock. Presentations of the company. Compliance with law. Since January 1st, 2022, yeah, so we can't go back that beyond that. This looks pretty standard stuff. Yeah. Mm-hmm. Well, conditions of the merger. Well, it's really early in the game. There's a specific performance section. Consent to jurisdiction. Yeah. Okay. So obviously, like, I was just looking for like some keywords and stuff along the way, trying to see what some keywords and some key sections were. Obviously, I wasn't reading the whole thing as I was skimming through, just looking for some keywords. But you know, on very, 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 very first blush, I think Twitter has a pretty solid case. Although I'm by no means ready to like say that Twitter is favored to win or anything by this. I'll just say that they seem to have a prima facie case. Which is about the nicest thing I think I can say at this point. And we'll go from there. Yeah. So let me check the super chats. I think I've read all the super chats along the way. Yeah, in fact, I know I have. So no super chats for me to do. You sound like you need a nap? Constantly. Constantly. What else? Anything else? I'm gonna do a bar what's prima facie? Prima facie? Just means on its face. Prima facie just means on its face. On its face, it makes sense. Prima just means first. Facie means face. First blush. On first impression, it looks fine. Do I just keep my kitchen clean? Yes, as a matter of fact, I do. Yeah, as a matter of fact, I do. I keep it clean. I use it every day. Did you look at my public trading company in the question? I don't know what you mean. Prima facie means able to pass a motion to dismiss. Well, I don't know if we're that far. It just looks okay on first blush and first impression. Motion dismiss means, well, first of all, we have to have valid causes of action, and it looks okay though. I don't see anything that's majorly wrong. But I'm not ready to say we're ready to. I'm not ready to say we're ready to. I'm not ready to say that we're going to make it pass the motion dismiss or not. It just looks like, on first reading, it looks logically consistent. Go to 6.11. We could do that. Let's take a quick look and see if 6.11 provides any value. Company shall shareholders use commercially reasonable efforts to cause each representatives at parent's sole expense, provide any reasonable cooperation requested by parent writing in connection with arrangement debt financing, subject to the requirements of 6.1 to pay off discharge of debt. Case may be necessary. Customer writing, providing notice, documentation, any payoff shall be subject to condition upon closing. Cooperation is not unreasonably or interfere with operations. Neither the company nor any of its subsidiaries shall be required to pay any commitment or similar fee, blah, 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 blah. So basically, we're required to provide information to help and facilitate closing. That seems consistent with what Twitter was saying. Yeah. I mean, it makes sense. It makes sense. We'll definitely get more into it. Thank you for your congratulations. I'm not sure what I'm being congratulated for, but thank you very much, Andrew, for congratulating me. How does a public trading company allow to have bots that can change the platform to manipulate the stock market based on usage and performance? Allowed to have bots? I don't know what you're talking about, Jay Gray. Bots are sort of an inevitable factor of life. Any electronic company of any size has bots. I don't know what you're talking about. Bots are a foreseeable and reasonable risk, or foreseeable risk of every electronic company, to some degree. Look at Cooper's liability. Who's Cooper? Neither company nor any person has made any other representations. Yeah, that's pretty standard. Okay, yeah. Nothing in here is striking me immediately, but there might be some details, of course, somewhere. There's a lot of, there's like, 50, 60 pages or something. So there's a lot of contract. There might be some things in here, but nothing striking me right at the moment. Earlier stream was 13,000 views. Kick ass. I was a little disappointed the stream didn't do as well, but sometimes you can't predict how well streams are going to do. You know, I thought that being Elon Musk, we'd do better than 350, but, you know, sometimes you can't predict how these things are going to be. But I enjoyed the 350 of you who were here and appreciate each and one of you. Thank you. Yeah. Okay. All right. So I'm going to sign off for now. Remember to do all the YouTubey things, like, comment, subscribe. And I will talk to you guys later. Until later, my friends, I hope all is well. Cheers, my friends, and